Well, hello, thank you so much. It's a true privilege to be here. I'm with the U.S. Department of Labor Wage and Hour Division. I'm here all the way from the Francis Perkins Building, which if you're not familiar with Washington, D.C., is right around the corner from here. And if you're not familiar with who Francis Perkins is, she was the very first female cabinet secretary. She was the Secretary of Labor under Franklin Delano Roosevelt, and during her time as Secretary of Labor, the Fair Labor Standards Act was passed, and the Fair Labor Standards Act of 1938, which sets the floor for wages, the federal minimum wage, and the ceiling for hours, the requirement for overtime pay. That created the Wage and Hour Division, which is my agency. So Wage and Hour Division, in addition to enforcing the Fair Labor Standards Act and other laws of general applicability around the country, enforces the Family and Medical Leave Act. And the Family and Medical Leave Act was passed in 1993. I'm here to talk with you a little bit about how the Family and Medical Leave Act defines a serious health condition. Under the FMLA, an employee can take, the FMLA allows employees to take protected time off from work for certain reasons. Since 1993, the reasons that employees can take leave, protected time off from work under the FMLA, are for the birth of a child or the adoption of a child, for a serious health condition, if the employee has a serious health condition that makes them unable to do their job, or for the care of a family member. So the FMLA since 1993 allows employees to take leave for bonding, for their own serious health condition, or to provide care for a family member who has a serious health condition. Now, since 2008, the FMLA also provides employees the entitlement to take leave for certain military family members. If you have for family members who are called to service in a foreign deployment, there are certain qualifying exigencies, and for either an active service family member or a veteran, in certain circumstances, if that family member, the veteran or the service member, has a serious injury or illness, the employee has an entitlement to leave under the FMLA as well. So the first entitlement of the FMLA, the first thing that the law provides is time. It tells employers that they have to allow employees to take time off for certain qualifying reasons. The next thing it does is it protects that time. So if an employee takes time off from work, the status that they held in their work, the level that they had of responsibility, the status, their standing at work is preserved. Whatever their standing is when they leave work, their standing is the same when they come back to work. And it prohibits employers from interfering with employees who use FMLA, who have a need for FMLA, and it prohibits discrimination against employees who have used FMLA leave. Another thing that it does, so apart from providing time off, providing protection against discrimination, assuring that a person has the right to return to their same job, is that it requires employers to continue employees' health benefits as though health insurance, as though they were at work. So those are the entitlements of the FMLA. Now let's go back to those reasons. Again, going back to 1993, the reasons that employees can take leave include for their own serious health condition and for the care of a family member who has a serious health condition. So what is a serious health condition under the FMLA? The law itself says that employees may take up to 12 weeks of leave because of a serious health condition. That's an illness, an injury, an impairment, a mental or physical condition that involves either inpatient care or continuing treatment by a healthcare provider. So going back to the statute, it entitles employees to take leave if they're under inpatient care. And under the implementing regulations, the Code of Federal Regulation in Title 29, Part 825 provides regulations for the FMLA. And under the FMLA regulations, inpatient care is considered care in a hospital, hospice, or a residential medical care facility overnight. So once an employee has a condition that necessitates that type of care, the situation can be a qualifying serious health condition. And then in addition to that, a condition that has a continuing need for treatment. So an employee or a patient who has a chronic condition, a permanent or long-term condition, a patient who for any reason is incapacitated for 3 or more days, and they have an in-person visit with a healthcare doctor and some kind of follow-up treatment. All of these are different ways that a health condition can be considered serious under the FMLA. So on August 28, 2018, the Wage and Hour Division issued a public response to a request for an opinion asking whether organ donation surgery can qualify as a serious health condition under the FMLA. So given the different varieties of conditions that can rise to the level of serious under the FMLA, the very first that the condition requires inpatient care can certainly apply to an individual who is donating an organ. If you have a person who is hospitalized overnight, much less for days or weeks, and the person is both that time that they're in the hospital and the time that they're recovering from being in the hospital would be available FMLA leave time. So when we answered the question in the opinion letter from August 28th, we answered that yes, donating an organ can be a qualifying serious health condition. There's nothing in either the statute or the regulations that would prohibit that would make it not available as a condition for leave. Some of the things that people have asked, does it matter if the donating the organ is voluntary? It does not matter that it's voluntary. In a certain sense, treatment being voluntary is true of all different kinds of medical conditions. And when an employer is deciding whether to approve or not a request for leave, when the FMLA is involved, there's not a basis for the employer to question the diagnosis that led to the person, whether there is a diagnosis or not that led to the person having a condition. The employer is looking at, and what Wage and Hour would look at, and what we would ask a healthcare provider in a position to verify the seriousness of a person's condition. What we all want to look at is an objective test, and objectively what the facts are of the condition. Does it require hospitalization? Is the person incapacitated? Will they be incapacitated if they don't have a treatment? And by incapacity, that means that the person is not able to perform a function of their job duties. So for example, if my job requires driving and I'm not able to drive, then I'm incapacitated for that job. If my job requires standing throughout the day and I'm not able to stand, I'm incapacitated for that job. So the FMLA doesn't, being incapacitated doesn't need to mean that you're permanently incapacitated or you're incapacitated in all areas. So in the opinion letter, we also noted that the fact that the person who's making the donation is otherwise in good health is not a factor. So in one sense, you can think of it the same way that a person is in good health and they have an accident. They don't lose their eligibility for FMLA leave if they're involved in an accident and they're hospitalized. They have an entitlement to FMLA leave if they're otherwise eligible, and their family member has the same entitlement. So the same is true for a person who would be donating an organ. It's also true that it has no bearing in that analysis whether the person who is making the donation is related to the person that's the recipient or not. So these are all points that we laid out in both the opinion letter and in a new frequently asked question that we added to the Wage and Hour Division website in this past January. So let me just stop for a second and make sure that you have the information for going to find this and other information about the FMLA. Or if you have questions, you have family members, you have other individuals you're in contact with who want to speak with someone who's professionally trained and experienced with FMLA enforcement. So first, the web site for the Wage and Hour Division is www.dol for Department of Labor /WHD. That stands for Wage and Hour Division. And then you can go from there, you can go to /opinion if you want to see opinion letters or request an opinion. You can go to dol.gov /WHD /FMLA for all of the FMLA information, links to all of the information that we provide, including FMLA frequently asked questions. Now the phone number, you can also go though on the website. If you go to dol.gov /WHD, you can find a map to find the Wage and Hour office nearest to you. So not the Francis Perkins building, but the one where they take walk-ins more easily and they answer and they help people who have complaints. You can go to the website to find that, but you can also call 1-866-4US-WAGE. That's 1-866-487-9243, and that's a toll-free line that will get you through to any of the Wage and Hour Divisions offices in the country. And let me just say very quickly then to wrap up a little bit about, it was mentioned before what the entitlements of the FMLA leave are, but there's also limits to what the law requires. So although it covers most employers, not all employers are subject to the FMLA. All public agencies are covered by the law, states at the local level, state or federal level. All schools are covered by the FMLA. And in the private sector, all employers who have 50 or more employees are covered by the FMLA. If you are working for a covered employer, you are eligible to take FMLA leave once you've worked at least 12 months, once you've worked at least 1,250 hours in the year before you need the leave, and once you've had and if you work at a location where there are at least 50 employees within 75 miles. So not quite all employees are covered, not quite all businesses are covered, and the law does not require paid leave. It is a requirement for unpaid leave, although there are provisions that employees are entitled to substitute paid leave that they have available if it might otherwise be qualifying. And we also have recently issued another opinion letter where we talk about stacking of leave if an employee has a preference to either the employer and the employer allows it. Let's say they use their paid leave and then they start their FMLA leave. We would say that the employer is obligated to designate the time off as FMLA leave as soon as they know that it's qualifying, because there's no authority under the FMLA for an employee to extend. If it allows 12 weeks, there's not a provision to be able to extend that period of time that they have the protection. So I think with that, I'll stop and look forward to questions on the panel discussion.
Thanks.
Thank you.